Hello, myself Vivek Jamwal from LEXIS and Company. My today's topic is trespass. Trespass. Tort law originated in England with the action of trespass. Initially, trespass was any wrongful conduct directly causing injury or loss. In modern law, trespass is an unauthorized entry upon land. A trespass gives the aggrieved party the right to lawsuit bring a civil lawsuit and collect damages and compensation for the interference and for any harm suffered. Trespass is an intentional tort or in some circumstances can be punished as a crime. Common law form of action. Trespass is one of the ancient form of action that arose under the common law of England as early as 13th century. It was considered a breach of king's peace for which the wrongdoer might be summoned before the king's court to respond in civil proceedings of the harm caused. Because the king's courts were primarily interested in land ownership disputes, the more personal action of trespass developed slowly at first. Around the middle of the 14th century, the clerks of the king's courts began routinely giving up writs that permitted a plaintiff to begin a trespass action. Before that time, criminal remedies for trespass were common. The courts were primarily concerned with punishing the trespasser rather than compensating the landowner. From the beginning, a defendant convicted of trespass was fined. A defendant who could not pay the fine was imprisoned. The fine in these criminal proceedings developed into an award of damages to the plaintiff. This change marked the beginning of the tort action under the common law. As trespass developed into means of compelling the defendant to compensate the plaintiff for the injury to his property interest, it took two forms: an action for the trespass on real property and an action for the injury to personal property. Trespass to land. In modern law, the word trespass is used most commonly to describe the intentional and wrongful invasion of another's real property. An action for trespass can be maintained by the owner or anyone else who has lawful right to occupy the real property, such as the owner of an apartment building, a tenant, or a member of the tenant's family. The action can be maintained against anyone who interferes with the right of the ownership or possession, whether the invasion is by a person or by something that the person has set in motion. For example, a hunter who enters fields where hunting is forbidden is a trespasser, and so is a company that throws rocks onto neighboring land when it is blasting. So let's take this in simple way. It means that when a person trespass or invade in another person's property, it means that he has trespassed, that he will be sued or under civil law for the trespass. It means that we cannot trespass, or we cannot, without his permission, we cannot invade in his property. If we do so, then we will charge for the trespass. Even every entry onto another's property is trespass, even if no harm is done to the property. A person who has a right to come onto the land may become a trespasser by committing wrongful act after entry. For example, a mail carrier has a privilege to walk up to sidewalk at a private home, but is not entitled to go through the front door. A person who enters property with permission but stays after he has been told to leave also commits a trespass. Moreover, an intruder cannot defend himself in a trespass action by showing that the plaintiff did not have completely valid legal right to the property. The reason for all these rules is that the action of trespass exists to prevent breaches of the case of the peace by protecting the quiet possession of real property. In a trespass action, the plaintiff does not have to show that the defendant intended to trespass, but only that she intended to do whatever caused the trespass. If it is no excuse that the trespasser mistakenly believed that she was not doing wrong or that she did not understand the wrong. A child can be trespasser as can a person who thought that she was on her own land. Injury to the property is not necessary for the defendant to be guilty of trespass. It means that injury is not necessary. If the person had trespassed the land, then he will be charged for the trespass. Although the amount of damages awarded will be generally reflect the extent of the harm done to the property. It means the amount of the damages awarded to the plaintiff will be seen accordingly on the basis of the harm to the property or harm to the person's property. Persons means plaintiff. For example, a person who could sue bird watchers who intruded onto his land but would probably receive only nominal damages. A farmer who discovers several persons cutting down valuable hardwood trees for firewood could recover a more substantial amount in damages. More the damage to a person's property, more will be compensation for that person. The compensation will not only be would not be equal to every person. The compensation would differ from person to person according to the damages. Trespassers are responsible for nearly all the consequences of their unlawful entry, including those that could not have been anticipated or are the result of nothing more wrongful than the trespass itself. For example, if a trespass carefully lights a fire in the stove of a lake cabin, or a fault in the stove causes the cabin to burn down, the trespasser can be held liable for the fire damage. It means any mistake done by the trespasser causes problems for the plaintiff, then he will be sued, he will be charged for the damages, and he have to pay the damages to the plaintiff. No matter if he has intention to do so or whatever. If he has trespassed that person's property, he will be charged. He have to pay the damages to the plaintiff. Courts have had to consider how far above and below the ground the right to possession or land extends. It may be a trespass to tunnel or mine under another person's property, to force water or soil under the property, or to build a foundation that crosses under the boundary line. So, in simple way, trespass doesn't see intention. If the person has intention or he doesn't have intention, he will be charged. He have to pay the damages accordingly. If the plaintiff suffered a loss, then the amount that the damages will be more. So, in simple way, we can say there is no intention seen. He have to pay the damages. Initial time, the courts or the kings doesn't see that the defendant or the trespasser will have to pay damages. They only punish the trespasser, but gradually, according to time, they realize that the damages should be given to the plaintiff by the trespasser. Thank you.